My name is Caroline Falconer. I'm the Secretary General of the SSC Arbitration Institute, and I'm welcoming you to this webinar that we are organizing together with International Law Association and the Institute for Transnational Arbitration. And I am so honored to get to speak to you about arbitration, access to justice, and the rule of law today. At the SSC Arbitration Institute, we have spent more than 100 years supporting businesses and states to solve disputes. And by doing that, by supporting international trade, we are also in the business of keeping peace through international trade. So all around the world, we are now seeing, as we all know, we are now seeing threats to the rule of law and to the access to justice. And that is the reason we're meeting you here today. So we see political pressures in various jurisdictions on both courts, practicing lawyers, arbitrators, as well as academia. And this is, of course, very serious. And I would like to introduce us to this webinar today with three main principles before I give the word to my excellent panel and our excellent moderator. But the three main principles I would like to start us off with is access to justice, rule of law, and independence. And they are very much at the heart of what we do at the SSC. And they are not just words for us. We live and breathe them every day. So at the SSC, we firmly believe that access to justice and the rule of law must be protected. And this is crucial for our society today. Arbitration, when done correctly, can really help guarantee these principles by providing a neutral and unbiased way to resolve disputes. And the SSC Arbitration Institute, located here in Stockholm, is completely independent. We are a non-governmental organization. We are an independent part of the Stockholm Chamber of Commerce, but we have no connection to the Swedish state or the government, and we are funded through our own fees. And this independence is key. This makes it possible for us to offer a neutral forum for disputes from around the world and for settling conflicts without political or commercial influence. And why do we talk about this from the SSC, from Stockholm, from Sweden? Well, it's very much due to our history. We have a very long history. We started in 1917. And so we've been up and running for more than 100 years. But it really became interesting, I must say, in the 70s, when we became the bridge between the East and the West. In 1977, there was an optional clause agreement entered into between the Soviet and the US. And that decided that disputes, commercial disputes between businesses in these two countries were to be resolved here in Stockholm. That sparked our journey, the SSC journey into international arbitration. And since then, we have had a very firm position in relation to disputes between the East and the West, the CIS region, Russia, China, as well as Eastern Europe, in relation very many times in relation to Western Europe, North America. We started out with the optional clause agreement between the Soviet and the US in the 70s, and then in the 80s we saw a cooperation agreement with China, resulting in very many Chinese disputes being resolved at the SSC. But that is not all. So today we see parties from 40 countries every year. We see almost 100 countries actually in the last 10 years. I think it's 93 countries in the last 10 years coming to the SSC to resolve mainly commercial disputes, but also investment disputes. And I think there are a number of reasons why the SSC has become this international player for disputes, commercial and investment disputes in the world. And one fact is that we offer a truly neutral venue. At the SSC, all parties are treated equally, all are respected and heard, and that is important. That goes hand in hand with access to justice and the rule of law, as well as independence and impartiality. So, but we're not only talking about today about geopolitical aspects, we're also talking about cost efficiency, I must say. There are issues in relation to arbitration and resolving disputes in total, irrespective of the way of resolving those disputes. You must have the funds to handle a dispute, to have your own representation, to also pay the arbitrators, to pay the institute if you go to an arbitration institute. So cost efficiency is something else we're going to talk about during this hour with you. And keeping costs reasonable is one of the main focuses at the SSC. Time is money, and we need to cut times as much as we can in arbitrations, because that is a way of resolving disputes in a cost-efficient manner. And these values are really more pressing than any time before. And that is the reason why we have joined forces today with the Institute for Transnational Arbitration and the Institute and the International Law Association in organizing this webinar. And the plan is for us, let's see if we can do it, but the plan is to answer the question if we are at the crossroads for international arbitration and the rule of law. So with those words, I would like to give the floor to Charles Chip Brower, chair of the the Institute of Transnational Arbitration. I'm sorry. Welcome.
Thank you so much. Good morning, good afternoon. I'm Chip Brower, chair of the ITA. Thank you to our friends and partners at the Stockholm Chamber of Commerce for inviting the ITA to participate in this important discussion. Thank you, Jake Lowther and Karina Baltag, for getting us organized. And thank you, participants, for being so generous with your time. The Stockholm Chamber of Commerce and the Institute for Transnational Arbitration share a commitment to promoting and defending the rule of law. We are not just service providers and learning organizations. We are values-driven organizations, and the rule of law is embedded in our DNA. Justice Jackson's Executive Trial Council at Nuremberg founded the IATA's parent organization in 1947 to promote the rule of law by educating lawyers in the United States and throughout the world. The ITA was established some 40 years later to promote ratification of the New York Convention, the Panama Convention, and the ICSID Convention in Latin America, and to train lawyers in the practice of international arbitration. At the time, only 5 of the 19 states in Central and South America had ratified the New York Convention, and only 3 had ratified the ICSID Convention. Well, times change, but the ITA continues to promote the rule of law through our task force on the rule of law in investment treaty practice, through our observer delegation to UNCITRAL Working Group 3, and through recent programs on U.S. policies relating to economic coercion, emerging pressures on the legal profession, and challenges to international law. Lord Bingham described the rule of law as the principle that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered in the courts. Now, it seems obvious that states have primary responsibility for securing the rule of law, but arbitration plays an important role in promoting and defending certain aspects of the rule of law, particularly in the international context. Arbitration provides access to justice before impartial tribunals. Arbitration ensures equality of treatment and the fairness of proceedings. Arbitration affords the possibility of worldwide enforcement. We should also be open, at least open to the possibility, just the possibility that arbitration may not always be the optimal medium for certain features, sometimes associated with the rule of law. So, for example, appellate review is thought to play a crucial role in upholding the rule of law by ensuring the correctness of decisions, by promoting consistency of outcomes, and by securing accountability and adjudication. It is, of course, possible to waive the entitlement to higher review, and it is possible that investment treaty tribunals generally get things right and have produced a body of generally coherent jurisprudence, at least on most issues, even without an opportunity for higher review. But that is not the same thing as saying that arbitration is ideally suited to every aspect of the rule of law. We should be open to discussion of any vulnerabilities. If there are better alternatives, we should embrace them. But at least in my experience, the evidence continues to support the conclusion that arbitration remains the most relevant, the most resilient, and the most trusted process for resolving the world's most complex commercial and investment disputes. Thank you and enjoy the program. Over to you, Krina.
Thank you very much, Chip. Thank you, Caroline, and welcome everybody to formally to the discussion. As mentioned, we're going to try to answer the question if indeed arbitration is at the crossroads and to what extent the rule of law can and should be upheld in the context of both commercial and investment arbitration. My name is Krina Baltag. I am the chair of the Academic Council of the Institute for Transnational Arbitration and member of the SEC Arbitration Institute board. I will be joined in this discussion by Caroline Falconer, the Secretary General of the SEC Arbitration Institute. Caroline comes at the helm of the SEC after several years as senior legal counsel at a major European energy company, and before that, several years in practice, private practice, focusing on litigation and arbitration. Professor Federico Ortino is Professor of International Economic Law at King's College London and co-director of the Center for International Governance and Dispute Resolution. Federico is a member of the ILA Committee on the Rule of Law and International Investment Law, who just finalized the report on investment arbitration and the rule of law. Bart and Legum. Bart is founding partner of Honlet Legum. Bart focuses on international arbitration, both commercial and investor state, with over 30 years of experience as arbitrator, counsel, and expert witness. Bart is the vice chair of the SEC Arbitration Institute board, and he's also designated member of the ICSID panel of conciliators. Now, we've heard quite a bit already on the rule of law, access to justice, equality, independence, neutrality. I just want to take you back slightly to a more formal definition, which was coined by the former Secretary General of the United Nations in his report on the rule of law and transitional justice in conflict and post-conflict societies. I recommend everybody to take a look. It's more timely than ever, this report on the rule of law. And the rule of law was defined as a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. Concepts such as justice and the rule of law, also in the words of the former Secretary General of the United Nations, are essential to the efforts to preserve and enhance human rights, encourage economic development, promote accountable governance, and peacefully resolve conflicts. They serve both to define goals and to determine methods. Now, when we refer to the notion of justice, we need to approach it not limited to the notion of substantive justice. Of course, justice on the merits is desired. But primarily, we should focus on the notion of justice from the point of view of a formal justice, that is access to the courts or to any other dispute resolution mechanism, and of course, means of recognizing and enforcing the outcomes of this dispute resolution mechanism. The legitimate expectations of the users are satisfied and the rule of law is preserved only if formal justice exists in any given society. Access to justice, understood as the most basic human right of a modern egalitarian legal system, should rather be properly framed as equal access to justice, since under the rule of law, each individual's case is worthy of equal consideration. And this is confirmed by the Universal Declaration of Human Rights in Article 8, referring to everyone's rights to an effective remedy, and by Article 6 of the European Convention on Human Rights, proclaiming the right to a fair trial. Now, we are going to structure the discussion in two parts. The first part will concern this formal access to justice, entering the gates of the arbitration, and how the rule of law and arbitration interact. And in the second part, we're going to look at one probably very timely aspect of the rule of law nowadays in the context of international arbitration, which is legal certainty and neutrality. So we'll begin with the first part and we'll address three topics: costs, as you could hear, duration, and the third one, access to the jurisdiction of the arbitral tribunal. So we'll begin with the costs in international arbitration. Cost and access to justice have been discussed quite frequently. Just to remind everybody that not long ago, for example, in the United Kingdom, following the Lord Woolf's reforms, Lord Justice Jackson was entrusted to review the civil litigation costs in the UK as an essential element of access to justice. And in this discussion on the costs, it was highlighted that it's not only the quantum of the costs and how proportional costs may be in making access to justice practicable, but it also the use of procedural tools which might make the proceedings more expensive than they should be. So I would turn to Caroline, and obviously cost effectiveness, issues of impecuniosity of parties in accessing arbitration, procedural tools such as security for costs are very well on the table of the SEC and in the arbitration rules. So perhaps we could start with Caroline.
You're muted.
I believe we cannot hear you, Caroline.
Can you hear me now?
Yes, yeah. Absolutely.
Thank you. I would like to actually start to say that one of the most used websites on the SSC website is the cost calculator. So we know, in addition to the SSC rules and the dispute resolution clauses we have there, but the cost issue is, of course, of great importance to everyone in arbitration. And to have a predictable model and to being able to predict very early on in the dispute and even before the dispute is at the institute is important. And for the SSC, we have a very clear cost regime. It's all in the rules, the arbitration rules and the SSC expedited rules. We have this cost calculator on the website, so you can know very early on how much will it cost, and we will keep to that. That is important to us. And well, as you already said, Karina, cost efficiency has been a great focus for the SSC for a long time. And we drew a parallel to the time, and we are going to come back to the time issue, which is equally important for arbitration practitioners and parties, especially parties in arbitrations. But what we see is we published a report on cost last year at the SSC, authored by Jake Lowther. So we see that the clear majority of the cost relates to the party representative. So 80 to 85% in general is in relation to the party representative. 15% approximately goes to the arbitrators, the tribunal, and 3%, I think it is, in average, goes to the institute. And this is in relation to the SSC, but I guess the numbers are fairly similar in other international arbitration institutes. So speed is really money, time is money when it comes to dispute resolution. As the longer it takes, the more it will cost, not only in relation to the arbitrators, but also in relation to mainly in relation to legal representation. So what can we do to give tools to parties to find cost efficiency in resolving disputes? And what we have done is to offer as many tools as possible. So we have the arbitration rules, for example, which all arbitral institutions have, but we also have the expedited arbitration rules since the mid-90s. We see them being used in disputes up to 10 million euro, so quite large disputes. Last year, all of those disputes, all the expedited arbitrations were resolved within half a year, which is quickly. You really can keep the cost down if you choose expedited arbitration instead of the arbitration rules. But then in addition to this, we have, of course, mediations as well, which is an even more cost-efficient way if you can resolve the disputes in that mediation. But the last new tool we added to the SSC toolbox is the SSC Express rules. And this is a way to have a very predictable time and cost scheme for resolving your dispute. You get 3 weeks. You get one legal expert to make a decision on the dispute. We have seen this a couple of times, and this is especially good when you don't have the time or the money to go into full-blown arbitration, or if you want to keep it very quick, to have a way to resolve a dispute before you become too unfriendly with each other. You can keep a very good position in the relationship to one another. We've seen this being used, for example, within a group of companies where going to full-blown arbitration is not an option, going to court is not an option, but this is an option. So I think this is really a good option for very many smaller parties as well. If you don't have the muscles to go into full-blown arbitration, this is what you can do. Maybe I go on. Something else that's very close to my heart is to think about the possibilities you have in choosing, drafting the arbitration clause or the dispute resolution clause. All institutes provide dispute resolution clauses. You can pick and choose. You can add them together. So at the SSC website, we have our clauses. But it's important to choose the right rules. So you can include a clause that says both the arbitration rules, and for easier, for less complex disputes, you can go to the expedited rules, or you can have a mediation to start with if both parties agree to that. You can also really think about the seat. Even if the seat is not a requirement for a hearing, but very often we see that the seat is where the hearing will be held. So if you choose to have your hearing in London or in Zurich, for example, that will be more expensive than going to Vilnius or to Stockholm for that matter. So that is also something I always talk to parties about or companies when drafting or negotiating arbitration clauses. Think about the aspects you bring into the arbitration. Do you want to have governing law from a third country, or can you keep the governing law very close to one of the parties or both parties? can you keep the seat or have the hearing in a low cost option that really can save you money? Really think about which rules to decide on. So that there are a number of different tools really in that stage of the dispute, or before we have a dispute, that are up to the parties to decide on. Maybe I stop there.
Thank you, Caroline. I would probably add the point that as we all know, arbitration doesn't have, similar to what courts have, that is the possibility of the parties to rely on legal aid. And that means that the parties, when deciding to go to arbitration, they have to understand not only how to reduce the costs, but also that they have to pay certain costs. And the other aspect of costs is, of course, arbitration is founded on party autonomy. And that means that once the parties have agreed to arbitrate, they have to pursue this dispute resolution mechanism. This in practice has triggered also certain complications when usually the claimant presents itself in a probably impecunious position, or in a bankruptcy or insolvency status at the time of the arbitration. And there are, of course, other tools or other instruments available, including third-party funding, but also possibilities of as Caroline said, to address the arbitration in a more expedited manner. Of course, the SEC arbitration rules have other tools which have been explored in practice. One is Article 38, security for costs, whereas the respondent could ask the arbitral tribunal to order security for costs for adverse costs if there is any suspicion that claimant would not be able to pay this at the end of the arbitration. And Article 39 of the SEC arbitration rules, this goes to duration as well, which concerns summary procedure. But talking about duration, we heard that time is money, but also justice delayed is justice denied. So perhaps, Bart, we can take in turn the issue of duration, something that was criticized along with costs as being the top two worst characteristics of arbitration.
Yes, so I think that in these times of great challenges for the rule of law, it is a common feature of many systems of administration of justice that governments are not putting the resources there to ensure that the courts can handle disputes as efficiently as most people in the public would like them to. And one of the advantages of international arbitration is its flexibility. It can be much faster than many national court systems can be. And the SEC Arbitration Institute has a culture of speed, where as soon as a request for arbitration is filed, the Institute pushes the parties at a pace that really puts the pedal to the metal, to use a US expression. And as a result, many of the disputes under the SEC rules are resolved in 6 months, and almost all of them are resolved in less than a year. Now, the larger cases and investment treaty arbitrations can go slower, but it is important to remember that with arbitration, you only get 1 day in court. Well, actually, many times the hearings are several days. But what I mean by that is that you only have one chance to prove your case on the law and prove your case on the facts to the arbitrators, because there is no appeal from an arbitration award. Instead, you can only seek annulment of an award on very limited grounds. And in cases where the stakes are high, parties are conscious of the fact that this is not a case that's going to drag on for years and years and go through multiple levels of appeal and go back to the lower courts and back up to the appellate courts and back to the lower courts before it's eventually resolved by settlement when the parties become exhausted. Instead, this is a case that likely will go to a decision before 3 arbitrators chosen because they are trusted by the parties to understand their dispute, and the result will be final and binding. So in thinking about the duration of arbitration, it's important to bear in mind that there's only one bite at the apple, and once that bite is done, then it is indeed done. So I think that's what I would say on duration, and we'll leave it open for discussion, Karina.
Well, my follow-up question is, of course, there is a difference between commercial and investment arbitration when it comes to duration and costs, of course. And if we look at the UNCITRAL Working Group 3 discussions, which are now well advanced in the proposed reforms, one of them being the appellate body that Chip was mentioning earlier. One early concern was raised in relation with duration, and the fact that investment arbitrations, quite in opposition, one would say, with commercial arbitration, they take very long. Is this something that is inherent to arbitrations involving states, perhaps, Bart?
I think that it is something inherent to arbitration involving states, particularly states in the investment treaty context, when typically coordination between multiple ministries within the same government is required to deal with a case. To take a typical case, a case involving a mine, the Ministry of Mines or Natural Resources will naturally be involved, but the Ministry of Foreign Affairs or the Ministry of Justice may also become involved because it's an international case, and that coordination between different parts of the government is something that takes time, and arbitrators and parties understand that it takes time. The other thing that I'd note is that there is a tendency on the part of states to think that certain things are a very good idea, except when it involves them in one specific case. So, for example, transparency. Transparency of proceedings has long been lauded as a very important goal. The Mauritius Convention was adopted to much applause by states, but it has not gone into force, or maybe it's gone into force, but there's only a small number of signatories at this point. And so states are the respondents. Respondents in arbitrations generally don't have an interest in moving the proceedings along very quickly, and states have many good reasons for not moving the proceedings along very quickly. So in some ways, it's a feature of investment treaty arbitration. That being said, there's certainly much more that can be done to make the process more efficient. And part of the issue that has developed in investment arbitration is delays in issuing the award after the last hearing, and that is something that can only be put on the arbitrators as being their issue rather than that of the parties.
Thank you, Bart. In the interest of time, we're going to move the discussion to the last point on our first part, which concerns the access to formal justice or entering the gates of arbitration. I was mentioning that jurisdiction of the arbitral tribunal is one important component in making sure that the parties do receive that substantive justice, and of course the rule of law is upheld. Now, there are various aspects when it comes to what the tribunal should pay attention at, what are the limitations on the competence of an arbitral tribunal. Recently, we had quite extensively attention, which we're going to address in our second part, between the powers or the legislation of supranational bodies or organizations, regional economic integration organizations, and national laws. We're going to talk about this tension with international law on the other side. And of course, the fact that arbitration, commercial arbitration in particular, sports arbitration, they have a seat of arbitration which also dictates what norms, legal norms applicable in the arbitration are norms, mandatory ones, or of public policy. And of course, the fact that arbitral awards, when taken to recognition and enforcement outside of the seat, they will receive that, let's say, consequence or impact of the laws of the forum of recognition and enforcement. In this particular discussion today, I suggest we focus, as I said, there are many aspects of the discussion, but one recent case, which is the Serang case, I would invite Federico perhaps to walk us through this tension between EU public policy and national policy, and to what extent there is, like in other instances, a cross-contamination with commercial arbitration from sports arbitration.
Yes, thank you, Krina, and thank you for the various institutes for the kind invitation. Well, this is it is quite an interesting case. In part, and in fact, we are at the moment waiting for a decision of the Court of Justice of the European Union, but we do have an opinion of the Advocate General that is quite interesting, raises certainly interesting aspects, and in a sense, it's an access to justice in both ways. Is it sort of, what is the extent that parties have access to arbitration as a dispute settlement mechanism, but also what is the ability of those parties to have access to a possible review in domestic courts. Now, the EU is quite interesting in that sense because it has now for quite some time, the Court of Justice has proclaimed that member states of the European Union must review arbitral awards from a perspective of EU public policy as well, and not only domestic public policy. That's sort of uncontroversial. Now, the specific case is interesting because we have a CAS award that basically confirms the fine issued and the sort of the lawfulness of this FIFA new rules that were introduced about 10 years ago, which the specific Belgian club, Serang, had found to have violated. We have that arbitration award. It was confirmed by a Swiss court. And so the parallel proceedings that the Belgian club had instituted before Belgian courts that sort of run parallel, but also unsuccessful because under Belgian private international law, a final award which has gone through a domestic court will be considered res judicata. And so the Court of Appeal in Brussels dismissed the claim because it considered the CAS award as res judicata. And so the claim, the request by the Belgian club to review the award, allegedly because it violated the EU law, particularly certain principles of the free movement under EU law, could not be reviewed. Now, the Cour de Cassation, who accepted the further review request by the Belgian club, has now referred the question to the Court of Justice And interestingly, the Advocate General has basically drawn two differences between commercial arbitration and sports arbitration. And the first one is that sport arbitration involving CAS is mandatory in nature. So teams, clubs and players can't choose, they have to follow it. And second, it also argued that CAS awards are self-enforcing. You don't really need to go to a domestic court to have that enforced, partly because it's one of the conditions of the players and the clubs to be able to continue play that sport. And so these two differences have been used by the Advocate General. She suggested that there should be, basically the Belgian private law that equates sort of a final award as res judicata and thus not be subject to reviewable, that should be declared invalid under EU law, because she argues that the Belgian club should have a direct judicial path to assess the EU law compatibility of the FIFA rules and thus the CAS award, which at the moment they don't have. But secondly, it also argues that this judicial review before a EU member state court should also be broader than the usual review based on public policy. That's also quite interesting. So, and in fact, she tries to get around the New York Convention by arguing, well, first of all, she says the New York Convention does not apply. She has an argument about the fact that because it's a mandatory arbitration, she says this is really not, the parties are not undertaking to the specific arbitration. But even if that argument doesn't work, she says that one could interpret the public policy grounds in the New York Convention, Article 5, broadly, in light of the EU public policy on guaranteeing effective judicial protection. And that's how she gets around to sort of avoiding the applicability of the New York Convention. Now, who knows what the court will do, but certainly this highlights one inherent tension that with the growth of arbitration as often a very effective and popular mechanism to settle disputes, beyond the classic ambit of private to private commercial transaction and disputes, it's become interesting that the system around it is trying to adapt, partly because of the various nature of this additional use of arbitration, whether it's investor-state arbitration or now mandatory sports arbitration. And I think the Advocate General has the merit of trying to make that point. Don't drag commercial arbitration into this specific type of arbitration, because otherwise, you may actually undermine, the broader animal. And at the same time, the question also, which has been put also by Chip in his introductory remark, is whether at the end of the day, is that simply a question of adapting sort of rules dealing with arbitration depending on the different kinds and features of arbitration, or one should actually perhaps be more strict and keep arbitration as a system to its core and sort of and being able to exclude this expansion of the system. Thank you.
And just Federico, I suggest we stay with you for the second part, as I was mentioning earlier, because your last remark is the perfect segue into what I mentioned earlier, and which is the reform of investment arbitration or investor-state dispute settlement in the UNCITRAL Working Group 3. And of course, these are various aspects. There are various aspects discussed there, but perhaps you could walk us a little bit through what is happening and we're talking about the rule of law, but ultimately we're discussing this because at the core of it is the question of legitimacy of international arbitration and something that we all have an interest in preserving.
Yes, I mean, it's quite complex. I mean, the whole process has sort of lasted now almost 10 years. So I think, it was quite quick when, the members participating in the discussions had to identify the problems, and, there's a long list of the concerns. And I think, in terms of, there are several concerns, although I think the difficulty is now to find solutions, right? Partly because I suspect there are different views on the gravity or the extent to which the various concerns identified, worry different states. But certainly, this idea of I mean, cost and duration was something which was identified as a concern. Happy to come back to it as well. The question of sort of the inconsistency and lack of correctness of arbitral awards. This is sort of also given, the 1,000 different treaties involved, the 1,000 different arbitrations, operating somewhat disconnected one from another to some extent. So those were certainly some of the concerns, to add in the end the question of the perceived lack of impartiality or independence of arbitrators. And I suspect that clearly there's a lot there, in terms of what to do. Now, the solutions which have been identified are several and again varied. When it comes to perhaps independence and impartiality of adjudicators, whether arbitrators or judges, depending on the configuration, a code of conduct that's what has sort of been prioritized. And in fact, the UNCITRAL has now produced 2 different codes of conduct when it comes to arbitrators and judges for investor-state dispute settlement. Not that they are sort of super innovative. There are a lot of things that have been developed over the years, the IBA rules, for example. Perhaps the one interesting novelty is the double hatting, which is sort of the multiple role that adjudicators may have, and that also creates perception of lack of impartiality or independence. That has now been somewhat curtailed in these codes. When it comes to the question of certainty and predictability and even correctness, which is sort of something that you asked us to think about in this concept. I mean, it's legal certainty may mean many things. In arbitration, you probably also think particularly the enforceability of the award. That also it's one of the key features of arbitration. Now, but there may be more than that, right? So clarity and predictability of the law, the consistency in applying this law. Now here it's where states diverge in assessments. Those that are proposing the establishment of a permanent multilateral investment court, with judges, whether it's 2 layers, first an appeal mechanism or just single. And those that sort of instead want to keep the current system based on arbitration, ad hoc arbitration, without any creation of anything permanent. The sort of compromise position seems to be one that keeps the current system as a first layer, but then adds an appeal mechanism, which is permanent, that is able to somewhat instill some level of coherence and predictability. But there are so many different tweaks and turns that one could have in formulating, the future ISDS, that it's difficult really to evaluate in details. which one will be pushing towards more certainty, and those that would push for more predictability, or correct it even. So it's difficult to sort of have a singular view. Certainly, there are various views among states at the moment participating in these discussions.
Just going back to something that was mentioned, of course, the certainty, but the very existence of arbitration as a dispute resolution mechanism for the resolution of investment disputes, something that Caroline has mentioned in the beginning, the role of arbitration as such. Bart, just going back to this issue, to the legitimacy of arbitration and the survival at the end of the day, in the context of investment arbitration, that was the preferred dispute resolution mechanism for various reasons, one of them being that it is free from political interference. Do you think that the multilateral investment court will solve the problem, or what are your views on of course, the role of arbitration preserved in the context of investment disputes? The SEC Arbitration Institute, just reiterating, has released recently a paper, Arbitrating for Peace. And of course, everybody's invited to check this on the SEC website. Bart, if you have thoughts.
Sure. Well, let's first go back to basics. So the reason why investor-state dispute settlement exists is because in many parts of the world, investors do not believe that they can bring a claim against the government for having violated their fundamental rights and have a fair day in court. The logical place, the most efficient place for any dispute against a government to be resolved is in the courts of that country. And the reason why you see every year still very significant numbers of investor-state dispute settlement cases filed is because investors don't have the confidence that they will have a fair hearing in the courts of that country. And that's the reason why investor-state dispute settlement exists. It's not because it is a perfect solution. Federico just referred to the many issues identified with investor-state dispute settlement. Those issues are there, but compared to the alternative, it's a much better alternative than having no access to justice at all. So that's why it exists. In terms of whether it makes more sense to have a multilateral investment court rather than ad hoc investment tribunals, that's a question that can be debated. There are reasonable views on both sides. The reality is that with the current system of investment law, which is a network of hundreds of treaties negotiated between different countries over a 50-year period with different provisions that the authors don't want to have interpreted to mean the same thing, having a single court to interpret those very varied instruments is not a solution that will result in coherence and consistency if indeed those instruments are interpreted the way that they should be interpreted. The latest generation investment treaty designed to correct the problems of the past, the authors of that treaty do not want it to be read like a first generation investment treaty from the 1970s. They want it to be read to mean what it says. They wanted to have the provisions that they've negotiated have some effectiveness. So a multilateral court is not going to do that. But there are good reasons to think about it. It would be potentially more efficient from a cost perspective, although there are remarkable challenges involved in figuring out how to fund the court. But then again, there's also the reality that international courts tend to, once established, view their roles as constitutional roles and sometimes do things that the countries that established them didn't necessarily intend for them to do. And it is much more difficult to tell an arbitral tribunal that other arbitral tribunals got the issue wrong when they decided it than it is to look judges of a court in the eye and say, you got it wrong when you decided this case last year. So there's consequences that go along with the multilateral investment court, but that's a much longer discussion.
Caroline, the SEC has the status of observer in the UNCITRAL Working Group 3, and of course the SEC has been actively involved in the discussions. In particular, one of the proposed reforms, which is reflected in a paper of the UNCITRAL Secretariat on procedural and cross-cutting issues, which has provisions including on cost, evidence, or others that go to what Bart was referring to the variety of investment treaties out there, trying to provide a uniform approach, such as the right to regulate and damages and so on and so forth. Caroline, what do you see, or how do you see the role of the arbitration institutions? And of course, you can be very specific, the role of the SEC in making sure that arbitration remains neutral, as you mentioned in your introduction, and that institutions uphold legal certainty and neutrality.
Thank you for a very good question, Karina. I think arbitral institutions have a crucial role in this, as I started with today. I think we need to work towards increased transparency when it comes to our procedures. What happens when you come to the SEC or ICC or any other arbitral institution? We are, of course, keeping confidentiality for the cases as such, but the process, we must be transparent here to bring trust in the procedures. Something I think, Bart, you were talking about that previously, that we try to be even more transparent. We try to publish awards, unidentified, anonymized awards on a yearly basis. But that's very hard because parties are unwilling to do that. They always respectfully decline. Instead of, but at the same time wanting to read everyone else's awards, but never having their own out in the public, even though they are anonymized, of course. So I think that there are a number of different ways for us to increase legal certainty and increase neutrality. We are on our way there. We have a lot already in place, of course, but what we are under my helm working very much on is increased transparency, actually, to be even more clear on what's happening at the SEC, and that is in line with our reports we're launching. We're doing a number of reports each year. We have a lot of information in our LinkedIn account, in our newsletter, in our website, and so on. And I think that is the way to go to bring trust to arbitration at large.
And to remind also that the SEC, when it comes to investment treaty disputes, provide the specific provisions which are found in Appendix 3 to the arbitration rules. And there the SEC has two very important provisions on submissions from non-disputing parties and submissions from non-disputing treaty parties, which again not only that provides access to those, let's put it broadly, societal interests, but also when it comes to interpretation of treaties, access to the other parties to the respective treaty in investment arbitration. I know that we ran out of time, but I do have one item on my list, which is the continuation of the discussion from the Saran case, which was the EU public policy and domestic law, but we have the bit on the tension between EU law and international law, public international law, which we have seen surfacing in different occasions, in particular when it comes to recognition and enforcement of disputes, and of course the importance of the seat of arbitration. I would just give the floor to Bart for maybe 20 seconds. I probably more specifically the Spanish cases, the saga of enforcing the arbitral awards. Where do you see this tension between public international law, treaty commitments, and public policy of regional economic integration organizations in light of the rule of law and access to justice?
Gosh, I'm not sure if I can answer that question in 20 seconds. I'm not even sure I can describe the problem in 20 seconds. But I think that there has been an issue posed in cases under the Energy Charter Treaty against member states of the European Union by investors of the European Union and its compatibility with EU law. And the reality, the objective reality is that international arbitration tribunals have overwhelmingly taken one approach to that issue, and the European Court of Justice has taken a different approach. And that approach has been declared by the court to represent public policy. As a result, there is this question as to whether the awards issued in the Spanish cases will be enforced within the European Union, or whether they can be enforced elsewhere. But I'm not sure that there's much more that I can say on that at this point.
Federico, you wrote extensively about the tension between EU law and public international law. If you have a quick view as to how do you see this, and perhaps if there is any resolution to this issue.
Well, difficult. It's two ships passing in the night. But certainly, as Bart said, public international law has won before tribunals, arbitral tribunals, and EU law has won in domestic courts. I mean, that's the situation. Now, particularly the second one is showing up in enforcement proceedings, if you need to, within the EU. Outside, you're fine. But at the moment, it's quite a big conflict that hasn't really been solved.
Well, and of course the SEC as hosting and in fact being the first institution to receive an Energy Charter Treaty case has experienced the tension between EU law and treaty commitments to quite an extent. So perhaps this is going to be subject to our next webinar, perhaps expanding on further issues of tensions and how the rule of law can be upheld in the context of treaty commitments made towards investors. I would go back to our original question, and perhaps we can conclude that while we might be at the crossroads, arbitration continues as a legitimate dispute resolution mechanism. And I will quote Bart, it is the best option at the moment. It may not be the perfect option for both commercial and investment cases, but certainly when it comes to the rule of law, as I was mentioning in the beginning, it's not up to one participant. Is it up to institutions, public and private entities, the state itself, and all the persons involved to make sure that the rule of law is upheld and access to justice is indeed effective, including at the stage of recognition and enforcement of arbitral awards. I would like to thank, first of all, Caroline, the SEC Arbitration Institute, the ILA and the ITA for hosting us today. And of course, the recording is going to be made available as well of the webinar, and we'll continue the discussion outside of this forum. Thank you and have a great rest of the day.